Please be seated. It's cause number 24-30207, Gomez versus City of New Orleans. Is the appellant ready to proceed? You may.
May it please this honorable court. Your Honor, I'm smiling today because the last time we were before this court, Hurricane Ida prevented us from being here physically in person. But the city of New Orleans and its people, just like it's shown time and time again, that they survived, and I'm glad to be here physically in person. Unfortunately, Your Honor, I'm not glad to be here for the reasons we're here. There are three issues before the court. The first is the biggest of them all, which is the court erred when it instructed the jury to answer a question of law concerning duty. And that was the city of New Orleans' duty that to make sure that it hired, retained, and properly supervised its employee officers. The second issue is, Your Honor, concerning the actual damages that were incurred by Mr. Gomez, the plaintiff, when he applied for public records through the public records request, and he was arbitrarily denied and made to wait all the way past his statutory deadline to file, which harmed him. The last issue are the attorney's fees that Mr. Gomez is mandatorily entitled to when there is a finding of a violation of the public records. I'll start with the first, and I'll start by reading to the court the actual jury instruction, which is at issue. This is the court. This is the lower court. Do you find by a preponderance of evidence that John Galman, the defendant officer, benefited from a unique opportunity provided by his employment as a police officer to cause harm to plaintiff Jorge Gomez as to give rise to a duty on the part of the defendant, City of New Orleans, to exercise reasonable care in either training or supervision or retention in regard to the 2018 incident that left Mr. Gomez on the ground bleeding profusely? And to that, Your Honor, we go through an entire trial. The jury gets this question, and we're not guessing, we're not speculating that they're confused. This question is proof that they were absolutely confused and didn't understand. This was the jury's question after, I might point out, they were deliberating for 2 days before they submitted this question. Instructions in the verdict sheet list different criteria for determination of preponderance. Instructions include was engaged in some way in furthering the employer's business, but the verdict form does not. Should this criterion be considered? To which the court responded, yes. The criterion you quote should be considered along with all the criteria on which you were instructed. The verdict form cannot incorporate into the questions all of the law contained in the instructions. Thus, you should consider all of the criteria on which you have been instructed. After receiving this response from the court, the jury came back in about 30 minutes, and they decided against, with the defendants in this case. And here's why this is hugely important, Your Honor. This was the very first jury question. So they never considered the elements at all that they were supposed to be considering. And what they were supposed to be considering was located on 5C of the jury questions. And that's what went through the elements, whether or not the city was unreasonable in its training, its supervision, retention. The jury never got to those questions at all because they thought that they had to decide whether or not the city of New Orleans owed a duty to a third party for its officers, mainly because this officer was off duty.
Counsel, can I ask you about, so in question 5A, the one you
Yes,
read,
Your Honor.
reading, would you have had an objection if it ended with the word Gomez?
We would have had an objection to it existing, period. 5A should not have been there, Your Honor.
So I understand your point about the duty, and I hear you, and I read your brief carefully, and I understand your argument. But the first part of that does seem like a factual question. right? Did you find by preponderance of the evidence that Galman benefited from a unique opportunity? You know, in our original panel decision, we said that this factual question about the unique opportunity, that unique opportunity is a factual question, benefit is a factual question.
Yes.
That triggers a legal duty. So I see your point that they're mixing these two things.
Yes, Your
But
Honor.
what I'm trying to figure out is where it goes from okay to not okay. And I would have thought you would tell me that no, actually it would be fine if it had just ended with Gomez.
Well, Your Honor, let me say this. We were adamantly opposed to the language at all because we knew it was confusing. The city's defense was the officers being off duty. That was their only defense and their best defense. So we were adamantly opposed to any of it. But on record, my counsel wonderfully argued to the court, hey, look, if you're going to submit this, then stop it at Gomez, which Your Honor just said. The court refused to do it. And we asked this, co-counsel asked this question before it even went to the jury. So when the jury came back with the question, there was a lot of conversation that was had in the courtroom specifically about, again, revisiting this, Your Honor. You've already submitted this question to them. So now please clarify for them. They've been out deliberating for 2 days. And if they're stuck on this first question, then a room has to be split. And their confusion is on duty. Duty of being on duty, being off duty. It's a question of law that this court answered on our motion to dismiss.
I'm sorry, I thought you said that the jury question was about preponderance.
It was, Your Honor. The jury question of, do you find by preponderance of evidence that John Galman benefited from a unique opportunity provided by his employment as a police officer to cause harm to plaintiff Jorge Gomez? If it would have been a period there, Your Honor, I doubt we would really have reason to be before this court. And we probably would have had to accept that.
And did I understand what you just said a minute ago, which is your very able co-counsel urged a period or whatever, question mark?
Yes.
End of the interrogatory.
Yes.
At Gomez.
We asked the court to remove it because it was confusing, because we saw that the judge was not moving off of.
And I just want to be clear, I'm understanding you to say you objected to it altogether. You were willing to compromise.
Yes.
What your proposition was, if you insist on using it, please then just put a period after Gomez.
Absolutely, Your Honor,
All right.
Graves. And the reason why is because this. As we're going through the trial, we never knew exactly what the defendant Galman was going to say at all, right? But when the defendant Galman is on the stand, and in particular, we'll get to this in the FOIA claim, we were after what's called a PIB report. In this PIB report, it discussed how Galman had, essentially they made an arrest, is what they did. I mean, they radio calling, saying that Galman called in using a special code. When prompted the question to Galman, because I was examining Galman, I asked him, why would you use a special code to call the police? He says, because they show up faster when you do it. That is a clear benefit, Your Honor. So when we saw how things were going at the trial and the evidence that we were going to be able to point to in our closing, we were fine with ultimately accepting this if it stopped at period from Gomez. And it didn't, Your Honor. And I have to say this. Your Honor, plaintiff was in, I'm trying to use my words wisely. We were in a bit of a hostile courtroom, Your Honor. And I'll tell you why. Throughout their entire proceedings, after we got back from this court and we proceeded to trial, we were constantly reminded about how the lower court disagreed with this court's finding and sending it back down. And I believe that a lot of that framed the decisions that were made, including, if there are no further questions on this, I'll move to the FOIA.
Well, counsel, did the district court, when you objected to that interrogatory, did the district court categorize the question as either a question of fact, a question of law, or a mixed question?
And Judge, thank you for that question, Your Honor. I'll tell you exactly what the court said. In the court's finding, the court basically said, and it was confused, I think the court may have been confused itself. The court says that the question of a duty is a factual question in relation to the harm that was caused. It was just so spaghetti.
Is that you have a record cite for that? Is that
We
on
do.
the transcript?
And Your Honor, I will get the record cite. I don't want to waste my time.
That's
During
fine.
rebuttal, I will have the actual record cite and read the quote to Your Honors to make sure that I'm on point. But the response from the court, in its ruling and its finding, essentially admitted that they told the jury to answer the question about duty. And I'll use this analogy in hopes that I'm reaching the court. If a school employs a teacher, and that teacher assaults a child after school, the jury is not going to be tasked with whether or not the school owed a duty to the third-party student. The jury is going to be asked, is there a causal relationship, right? Did they know? Should they have retained this teacher? Should they have removed this teacher? Those are the things that the jury should have been instructed on. Whether or not the call in saying that they were officers off duty, whether or not the apprehension, and more importantly, I haven't even got to this, I saved this for last. When we finally got the discovery in the case, we got the discovery literally in discovery when we should have got the stuff in a public information request. There's a body-worn camera of the initial officers who arrived on scene. Officer Galman is out of the car. First of all, he's out of the car. Either one of us would be in the car in handcuffs. He's out of the car. He's allowed to smoke on a vape pen, and he tells the officer who responded, man, this thing is going to all blow over like it did the last time. And what he was referencing, Your Honor, was he was off duty, walking across the street. He became upset at a woman who got too close to him in a crosswalk, and he proceeds to walk over to the car, and he karate chops her side view mirror off. He was reprimanded for that, and at that point, Your Honor, is where we argued to the jury that there's no way an officer in a probationary period displaying this type of violence and unruliness should have been kept on. And there was other evidence as well, Your Honor, of being trained and improperly being trained and doing illegal strip searches while out in the field. There was more than enough information to the city of New Orleans that they had a problem. And there are officers like that make it hard for the officers who follow the rules and lay down their lives for the citizens of New Orleans. I want to spend my last 3 minutes on the public records request. Your Honor, I'll provide a little bit more context on why we believe that we were in a bit of a hostile courtroom. We were continued to be reminded of the disagreement of the lower court with the finding of this court, Your Honor. And we pointed out in a timeline of how we believe it was deliberate that the city of New Orleans decided not to give us the documents that we needed until 2 days after the statute. They didn't give us anything, and then they told us that it was voluminous or we were dealing with a lot of requests. They pointed to absolutely nothing at all in the record to say this volume or that it was voluminous. And in fact, when we actually got the discovery, Your Honor, it was not voluminous. This wasn't a case where these officers had a long career and they had to submit a bunch of records. This also wasn't a case where we didn't know what happened. These officers were eventually charged. They both pled guilty. And Your Honor, we didn't get anything. More striking and noticeably is this. The body-worn camera that I spoke to Your Honors about. We didn't even get that when they finally responded 2 days after we filed the complaint. We didn't get the video until we were in discovery, where we finally got a chance to look at the video and actually hear this officer saying, man, this is going to all blow over, just like the last time. Your Honor, from that point, the court found a violation, right? There was no discrepancies as to part of violation or half a violation. The ruling says they found a violation. They awarded $17,000 in civil penalties. At that point, Your Honor, it's not up for debate. We were supposed to get mandatory attorney's fees because it sent us on an odyssey of litigation that had us in front of this court. Now, I was actually excited because I had never argued before this honorable court, so I was excited to be here, but we shouldn't have been here, Your Honor. If we would have gotten the information from the PIB and the body-worn camera and been able to plead that in our complaint, Your Honor, we survive a motion to dismiss, and we're not on a tailspin of arguing the motion to dismiss on appeal. Then once it comes back on appeal, we're now arguing in front of the court and getting discovery that we should have had. This case has been since 2019 when we filed. It is now 2025. This case could have possibly been resolved at least 3 years earlier had the city of New Orleans handed over the documents they were required to hand us. And they didn't do it because it was voluminous. This case was well known, and they knew when the deadline was running as well. We had our hands tied. We were investigating. We as a firm do not bring complaints against officers unless we fully vet them out and we see the evidence there. They kept us from that evidence. Our client was in a bar enjoying a beer, and he was wearing a camouflage jacket that he always wore because he was a retired vet, and he was proud of that. And for no other reason alone, he was berated and beaten almost to death. I'll save my time. Thank you, Your Honor.
Thank you, counsel. Mr. Raymond,
St. Raymond.
you may proceed. St. Raymond, you may proceed.
Good afternoon, Corwin St. Raymond on behalf of the city of New Orleans. To put it simply, this case is about a bar fight, okay? This bar fight occurred on the early morning hours of July 24th, 2018. A year later, plaintiff filed suit against the city, against the two off-duty officers, Spencer Sutton and John Galman. The city filed the Rule 12 motion regarding the complaint. The district court granted the Rule 12 motion, dismissed nearly everything in the complaint that was brought in the complaint, except when this court reversed the district court, finding that Gomez had pled a claim for negligent hiring supervision against the city, and also that he had a potential viable claim for Fourth Amendment violation against the two off-duty officers.
What did the prior panel say about the question of law?
The question of law regarding
Duty.
the duty, it was that as officers, I think I have the exactly what it is. Bear with me. As a matter of law, the city had a duty to exercise reasonable care in the training, supervision, and retention of police officers because...
Right. Now, did you tell the trial court after the case went back down that duty was a question of fact?
We put... Your Honor, I think the jury instructions that were proposed were a little wonky.
Well, wonky is an understatement, but let me ask my question again. Did you assert, counsel said he objected to the question on grounds that it was a question of law, and did you assert, or your counterpart at the trial court level, assert that it was a question of fact?
I don't recall if we took a position on that, Your Honor, but I did find that the question that was the questions that were drafted by the court, as Judge Oldham referenced, is the first part of this question is factual. The second part of the question is arguably a legal question.
Oh, well, it's not arguable if we held in a prior opinion that it was a legal question, unless the Supreme Court reverses us on that. That's established as a matter of law, isn't it?
Fair enough, but I do think that the instructions that were provided by the court, by the district court, did provide that statement that I just read to you, specifically that there was a duty, officers in performance of their duty, have a unique opportunity to cause harm to the public. So the only two claims that proceeded to trial was the claim against John Galman for his alleged Fourth Amendment violation for acting under the color of law and using excessive force against Gomez, and then the state law claim against the city of New Orleans. After the trial, the first question that was posed to the jury was, did John Galman act under the color of law? The answer to that question was no. It's apparent that plaintiff accepts that result because they did not appeal that finding. The second question was what we've been talking about, right? So the issue here is can plaintiff or appellant overcome what he needs to overcome with respect to this jury charge challenge. Binder versus Brumley provides that the charge as a whole needs to create a substantial doubt whether the instructions properly guided the jury. And then second, even if the instructions were erroneous, the outcome of the case would have been different. It's the city's position that, yes, I can agree that the charge is potentially problematic, or the question that was posed is problematic. My issue is that the facts do not support.
Well, it's only potentially problematic if it's not used at the trial. If it's used at the trial and it's a problem, we're past potential. It's the instruction the jury was given.
Yes, but the instructions have to be.
So what do you mean potentially problematic?
Well, because the facts that were presented at the trial established that the city was not responsible for this incident. The jury unquestionably determined that John Galman did not act under the color of the law that night. The case law supports the fact that if Gomez was unable to show that John Galman acted under the color of law that night, then he does not necessarily, he could not make the causation jump to find the city responsible for negligence under state law. And we cited two cases from the Louisiana Supreme Court and the Third Circuit Court of Appeals that stand for that exact proposition. The Third Circuit specifically addressed this very issue. And it was on a summary judgment. It wasn't on a trial, a jury trial, but the summary judgment was granted finding that the officer did not act under color of law during his incident. The Third Circuit Court of Appeal found, well, if he didn't act under the color of law in that finding, and we agree with that finding, then there's no way the city could have been responsible.
So you're saying that if we accept the jury's verdict on the Section 1983 claim, that predomits any issue as to the unique opportunity from the hiring by the city?
Absolutely. Yes, it does. Because the finding of the evidence that was presented, and I've put all this into my briefing, the evidence that was presented to the jury reflected a number of things. I mean, that Galman didn't meet Jorge Gomez as a result of his employment. They met late at night, early morning hours at a bar room. Both John Galman and Spencer Sutton were off duty at the time.
But that's the under color of law question. What we started out with, which was the interrogatory 5, which relates to the unique opportunity that they, through their employment as police officers, even though they were acting outside of the course and scope of their employment, had a unique opportunity to perpetrate an injury that they're suing for here. My question was, and you answered it, but it seems like you're circling back on me, though.
Oh, I'm sorry.
That's okay. That's okay. I just want to be clear in what I'm asking.
Sure.
Does the city's liability end with the first question on the interrogatory form, or do we also get into the unique opportunity factual question, which also has to do with the negligent hiring, that you equip people with guns, badges, handcuffs, what have you, even when they're off duty, and the city has allowed them to assert that authority, as the plaintiff argues here. Why would the jury's verdict on the 1983 claim preclude any further fact-finding as to the unique opportunity question?
Well, I would say because the officers are entitled to a personal life. And so when you get off of duty, yes, you're always a police officer. Just like we're always lawyers, right? My bar number is never going to leave me until the Supreme Court says I don't have it or I expire. Just like an officer, the same situation. These guys became uncommissioned officers once the city terminated them. They were commissioned officers at the time of the incident. But were they acting as police officers? And I believe the facts and evidence unquestionably show that they were not. If they were not acting under the color of law that night, then why would the city be responsible for an incident that occurred in the middle of the night at a bar concerning military service? It didn't concern anything other than that, and the testimony reflected that. So that's why I get into the Binder versus Brumley issues, because no matter what, is that you got to show that also the result would have been different. the case law supports my position too. The Third Circuit and the Supreme Court have said, from Louisiana, have said, in order to have a negligent hiring, retention, or supervision claim, you have to prove you have to have an injury that was caused by the employee. Without the finding that the employee caused an injury, then there's no finding against the city or the municipality. And those two cases are Morgan versus Richard, 305 Southern 3rd, 932. They said that the ability to recover on a claim for negligent training and supervision is contingent upon a successful claim against an officer for false arrest and use of excessive force. That's exactly what we have here. So the Third Circuit Court in Louisiana has found that in order to have this claim, in this particular context, you have got to prove that the officer violated your rights. So Martin versus Thomas, the employer can only be liable for negligent hiring, retention, and supervision if the employee is at fault. The employer cannot be liable if the employee is not at fault. That's exactly what we have here. The jury was presented with facts, evidence, they reviewed it, they resoundingly said, no. And Gomez has accepted that Galman was not acting under the color of law that night. I don't understand, and I can't make sense of a finding that the city would then somehow be responsible if your claim was against him that he violated your rights, and the jury said no. Then how could the city ever be responsible for that? So, do you guys have any? I want to make sure I address all your issues. If there's anything else I need to respond to, I can move on to the Public Records Act claim.
I would just ask that you not refer to the panel as you guys.
I'm sorry. Apologies. Turning now to the Gomez's other assignments of errors regarding the Louisiana Public Records claim. Now, Gomez brought this claim as the last 2 pages of his complaint, okay? Ordinarily, a Louisiana Public Records Act claim is brought in the Louisiana State Court. It's heard in a summary fashion within 2 to 10 days of its filing. In this case, a complaint was filed and the action was the last 2 pages of the complaint. At no time during the pendency of the litigation in Eastern District did Gomez ask for that claim to be heard in an expedited fashion or anything like that. We filed motions, we went through motions. The city provided records during the pendency of the proceeding. We also provided records by way of discovery. And so we, the city, had a right, when we received the public records request, state law indicates that the city needs to do one of 3 things. They can provide the records, they can deny the request, or third, they can tell the requesting party that they need additional time. The city gave notice that we needed additional time to provide the records. And the records were, each of the requests, the first one was expansive, and it took 2 months for the NOPD to provide the records. Now, it did occur after the complaint was filed, but the suggestion that the city was tracking prescription or that the city knew that Gomez was going to file a lawsuit against the city is just not based in fact. Actually, the people that handle the public records are generally lay people at NOPD. So it's not coming through my office where we're saying, hey, be on the lookout, hold this stuff up because we're concerned about prescription and we want to prejudice someone. That's not what happened here, and there's no evidence of that.
How do you distinguish, I'm looking at Heath versus City of Alexandria and Johnson versus City of Pineville. How do you distinguish those cases that talk about when the custodian produces records after the suit is filed? And in this case, there's a reasonable amount of time to produce. How do you distinguish those cases? They seem to suggest that he's entitled to attorney's fees.
Well, I would say that the distinguishment, I'm not familiar with the facts exactly of those cases, but we received the request and we provided a response, and that's what's required under the law. So under the law, we have a right to say, hey, look, we got to find these records, we got to compile these records. It's not, the law is very stringent. At the time this case, in 2018, the law was 3 days that a public agency had to provide records. It's since been changed to 5. But that time period is stringent. Like, you either have to give the records, you have to say you're not getting the records, or the third option, which is, hey, we need more time, we're going to give you the records when we get them together. That's what we did, and that's what's allowed under the law. Now, I understand that counsel for plaintiff wasn't happy with the timing of that, but it wasn't nefarious. It was that we just, the NOPD gets a lot of requests. In the briefing, I think it was somewhere around 8,000 requests in 2018. So it's significant, and it's only gone up in the last few years. So,
but doesn't that depend too on the volume? He made a point about the volume of documents. If you file a request that is very voluminous, then obviously it's reasonable to take more time to do a production.
Yes, and that's exactly what.
Whereas if he's very specific and targeted, then the amount of time needed to respond would correspondingly be shorter, and thus the claim for attorney's fees would be stronger. Would you agree with that as a general principle?
Sure. If you're asking for, I want a copy of so-and-so's calendar for a certain day. Mm-hmm. Well, that's not a voluminous request. That's a simple thing. Just pull up the calendar, give them the document. In this case, it was a lot of things were requested. All training records, all police reports, it was some subset of 9 different things, all videos, all things and at the time the request was made too, is that these guys' criminal proceedings were still pending. So there was a question as to whether or not those records were even available to them because of the pendency of their criminal prosecution. So yes, when you do have a voluminous request, you do have an opportunity to ask for additional time. That's what we did here. It wasn't a finite request. It was a bunch of stuff. And so we provided in every instance for all 4 requests. Only one was filed before the lawsuit was filed. The other 3 came after the lawsuit. Admittedly, and the city acknowledged this, that the very first request we did not respond to within the 3 days. It took us, I believe, 7 days to give notice to them to say, hey, we're going to need more time. So I fell on the sword next door, and I said, look, we did not respond to that request within the statutory 3 days. We didn't give the notice. The Judge Ash found that they were entitled to a penalty for that, and he gave it to them. Now, the question it becomes is, did they prevail on all issues for their public records request claim? And that's no. We provided documents. We weren't arbitrary and capricious. The Judge Ash found that we weren't arbitrary and capricious in providing our response in the records. And that finding is, my understanding, is subject to abuse of discretion. So I think that there's nothing really in the record to show that we acted arbitrary or capricious. I'll just end because I'm running out of time. I think it's important again to reiterate that Gomez, there are no facts to support a claim against the city for negligent hiring, retention, or supervision. Okay, the facts were presented to the jury. These guys were out at a bar late at night. The discussion was about military service. John Galman became upset because he believed that Gomez was lying about his military service. He took deep offense to this, and the fight occurred. The fight started at the bar. It was brief. It broke up. These 2 gentlemen, the 2 off-duty officers, walked down the street, okay? They got down 2 blocks down the street, and this is in the record. Gomez drove past 2 streets that led directly to his home, and he intercepted those 2 guys past his house, and that's where the second fight happened, and that's where it got really bad. And we don't have any camera footage of what happened there, but Gomez said at trial, now, and I'm going to point this out because it's important, because the Fifth Circuit relied on the statements that was made in the complaint when it reversed the Rule 12 motion, that they acted like police officers. Gomez testified at trial that he stopped his vehicle because he thought they were Marines, and they acted like Marines. They weren't police officers. They weren't acting like police officers that night. One of these guys was a former Marine. He was upset, and Gomez was also in the service, and there was a disagreement about that. And that's what this case was about. It had nothing to do with these guys' employment with the city of New Orleans. I appreciate the time. And
Thank
I
you, Counsel.
apologize.
Thank you. Rebuttal.
And if it may please the court, I want to start off with the last question Your Honor posed about the response from the court about our objection to the 5A question. The court's response was this. The court tried to frame the duty instruction to allow the factual issues that were identified by the Fifth Circuit as related to duty to be decided by the fact finder, which is the unique opportunity question primarily. And without that, there's not a duty. So it's not a legal finding that there is an established duty. It's that there is a general duty, and that whether in the factual circumstances as found by the fact finder, it gives rise to that duty in this instance. Even the judge's reasoning is totally off base with duty. And Judge, I want to pick, I forgot which of your honors asked the question about the color of law, but I want to make sure I hammer this. The color of law is absolutely relevant to the duty that is owed of retention and training. And I'll also argue this, Your Honor. It's pure speculation that the jury found that there was no color of law. What we believe happened, Your Honor, was the jury said to themselves, well, these guys were off duty, and we've been told that we have to find whether or not there's a duty. So we find that they weren't, working at the time, and this is why they concluded. We believe that duty question and instruction totally confused them about the entire case. And we say that, Your Honor, because of this. We don't have to guess whether or not they were liable. They pled guilty. We know they caused the injury. The only question before the jury was whether or not there was a causal connection and whether or not they should have been retained. And I'll briefly say this in that retention part. I am a South Side of Chicago boy raised, but my grandmother is from down south, and she was a disciplinarian. I mean, for real. But what she would do is explain to you why she's disciplining you, so that way you wouldn't do what? Do it again. In this instance, Officer Galman is on a recording saying, this is going to blow over just like the last time. It was the duty of the city of New Orleans not to retain an officer who had racked up complaints while in his 90-day probationary period. Mr. Gomez was robbed of his day of court. And he was robbed of his day of court because the jury was confused as to what they had to decide. They were not supposed to decide.
Were there against Galman?
I'm sorry.
How many complaints were there against Galman during his probationary period?
There was the first complaint about him improperly strip searching someone, basically, in public, strip searching them. Then there was a complaint about the karate chopping of the woman's, rear view mirror. And then it was this. But that rear view mirror was very close into relation of this incident. And he said it for himself, Your Honor.
All of that was within a 90-day period.
All of that was within 90 days. 90 days, which is why I want to save the last minute for answering the public records request. Your Honor, how could there be a voluminous record on this officer who worked for less than 90 days? He didn't have a lot of training. As a matter of fact, he really didn't have any training at all, is what we found. And for the city to sit and stand and say, oh, we're not tracking this, we don't know about this. This was a huge case because of Mr. Gomez being in the service and how bad his face looked. The city called a meeting. It was an open meeting where the city council was asking specific questions about why wasn't there more training? Why was this guy retained? You know how they were able to ask those questions? because they had the records that we sought and that we should have gotten. And more proof and evidence that this was not just an accident as this. When they did comply with the public records request, they never gave us the video. We never got that video until this honorable court sent us back down and allowed us to proceed to discovery. So if it wasn't for your honors in this court allowing us to proceed just to discovery, we would have never heard Officer Galman admitting why he did it. He didn't do it for any other reason but because he knew that he was going to benefit from his employment as a New Orleans police officer, and benefit he did. Your honors, we are asking that this court please, once again, send us back down and allow Mr. Gomez his day in court. I have 17 seconds left. If your honors have no questions, I thank you again for allowing me to appear and argue on behalf of my client. Thank you.
All right. Thank you, counsel. That concludes the matters that are on today's docket. The court will